Hi, it's John Khosravi. I came across some very interesting information based on a due diligence question submitted by Senator Wyden to CBP, the nominee for the Commissioner of U.S. Customs and Border Protection, that I want to share with all you to help you and with your clients. On February 20th, 2017, Senator Wyden sent a letter to the Department of Homeland Security with questions related to border searches of personal electronic devices of U.S. persons. The department responded to these questions on May 9, 2017. In the letters, Senator Wyden asked what legal authority permitted CBP to ask for on demand as a condition of entry that a U.S. person disclose their social media or email account password. The response is very interesting, and this is a great piece of information, something to keep in mind when you're traveling yourself and you have a lot of evidence and information, documentation of your clients and other personal kind of information, and you're a U.S. citizen. First of all, under the regulations that the CBP officer provided in response is this. Under 8 U.S.C. section 1357C, it authorizes a search without a warrant of the personal effects in the possession of any person seeking admission to the United States if the officer may have reasonable cause to suspect that grounds exist for denial of admission to the U.S. As such, a U.S. citizen is not going to be able to be denied admission strictly because they are a U.S. citizen. So these kind of searches can't be pushed on them. Now, CBP does say that it must determine the admissibility of both the traveler and his or her company goods and baggage even after a returning U.S. citizen has established his or her identity as a U.S. citizen, because they want to search for any illegal or dangerous kind of products on them. They go on to say, in exceedingly rare circumstances, when CBP seeks to conduct a border search of information in an electronic device, which affects less than 0.01% of travelers arriving in the U.S., CBP will never prevent a U.S. citizen from entering the United States because of a need to inspect that traveler's devices. So again, they reiterate here, U.S. citizens can't be prevented from re-entering the United States if they don't provide this sort of electronic information. Although they could detain and hold on to the arriving travelers' electronic devices for further examination, they go on to specify that CBP can't do electronic searches of information that's not physically inside that electronic device, for example, on the cell phone. If the information is stored on the cloud, for example, in Dropbox or in Facebook or Twitter or social media like that, they're not allowed to access that information that's stored on the cloud, whether the cloud server is domestic or foreign. Now, they say with the assistance of the traveler, meaning the traveler giving in and accepting this, they could get passcodes and go do these kind of searches, but it's with their assistance. It's not mandatory. So as a practice pointer, if you're a practitioner, don't store sensitive information, sensitive pictures on the phone. Put it on the cloud and have a system where you have to access it on a cloud. Now, it gets a little hard, and I'm not sure how it's practically going to happen. For example, having all your files on Dropbox is great because you can access them anywhere, and because it's considered to be on the cloud, it's unsearchable. But if the officer gets the phone and opens the app and no password's required because it's already stored in there, would that allow them to search it? Or for example, on my phone, every picture I take immediately goes to my cloud. However, it stores on my phone as well, so I have easier and faster access to it. So even though partially it's on the cloud, the fact that it's on my phone still makes it subject to search. So if there are sensitive pieces of information, don't store it on the physical phone. You should, when traveling, store it on the cloud for extra safety. The memo goes on to repeat these points I just made a few times about U.S. citizens being allowed to enter, not being forced to provide passwords and cloud access, but with them being permitted to hold on to the electronic device. But I thought it's really important information because as immigration attorneys, we have very sensitive information of our clients that CBP is interested in learning about because it directly affects their job. So storing that information off the phone on the cloud, not storing it on the hard drive of the phone, is going to be key. Now, if it's on the laptop, they could search that as well because it's physically in the laptop. But if the file is stored on the cloud, on Dropbox, for example, and you access it electronically, they're not allowed to access that because they have to go and search the cloud. So in a modern immigration practice, one aspect of it might be to never actually store things on an electronic device that you're transferring with you when traveling internationally and subject to CBP inspection. If you have a hard drive in your office that you connect to your laptop, that's one thing. Storing the rest of the information on the cloud is another. But if it's stored on the actual laptop and you're traveling internationally, it could be searched. So if you are traveling, you have thoughts about maybe doing some work on the plane, only store the files that are necessary for work on the plane. Don't store anything else because it would be subject to search. I'm John Khosravi.